Okay, folks, let's get started. This is a criminal procedure video topic. It's linked to Chapter 8, Part B2 in the Miller and Wright text. We're talking now about witnesses and proof that are available at trial. The Confrontation Clause of the U.S. Constitution prioritizes live witness testimony over statements made outside the courtroom. So it's very relevant to this question of what witnesses are available and what proof will be available. I'm going to describe here the basics of the doctrine, particularly as it relates to unavailable witnesses. And then when we get together next for discussion, we're going to delve more deeply into, first of all, the historical and policy background for this complicated doctrine. And then second, we'll be talking about the likely effects of this doctrine in a couple of different high-volume contexts. So let's jump in. We'll start with the text of the Sixth Amendment, the right to be confronted with the witnesses against him. Now, to understand the importance of this clause, you have to sort of pull back and understand the world context for criminal procedure. Having a trial where it's the oral event and the key evidence is live testimony is not the usual arrangement. Normally, when we're building a criminal case, we're building a file, and the written record is the main source of the evidence. But in the United States, traditionally, the main event is the trial with oral testimony as the centerpiece of that trial. And when you have oral testimony, adversarial testing of that testimony is the main mechanism available in the U.S. to a defendant who wants to test the reliability of the government's evidence. Now, this preference for live testimony shows up in several different contexts. It shows up whenever we're talking about witnesses who make statements outside the court, but then when it's time for trial, they're not available, and so you want to bring their statement into evidence. That's the primary topic for my remarks here today. But it also happens when there's a co-defendant who might be sitting in the courtroom but not available because he or she has the privilege against self-incrimination. That co-defendant may have made a statement. Under what circumstances can it come in against the co-defendant, even if it might hurt me? This is called the Bruton Doctrine. This is also relevant in some less common situations, for instance, where a witness might be present and testifying but shielded in some way from the normal face-to-face interaction in the courtroom. Perhaps they're testifying but in a room down the hall with some kind of live video feed. Or perhaps they're in the room but testifying with a disguise on because they're concerned about future safety, because somebody might try to intimidate them or harm them after trial because of their testimony. The Confrontation Clause is relevant to those special shielding arrangements. And then the Confrontation Clause is also relevant to the rules of cross-examination that say normally you can't ask a witness about certain prior convictions or pending charges, or perhaps you can't explore topics that weren't relevant to what was brought up on direct examination. All those normal rules of evidence that might limit the scope of cross-examination might be put on hold or limited by the Confrontation Clause, where a defense counsel might be able to pursue those questions even though the rules of evidence normally wouldn't allow it, and that's because of this right of confrontation. Let's imagine this very common setting. The prosecution has some record of what a key prosecution witness said in the past, but the witness can't testify now in trial. Maybe that witness is dead. Maybe the witness is invoking the Fifth Amendment privilege against self-incrimination. Maybe the witness is just missing, has left the jurisdiction. For whatever reason, you can't have live testimony, and so the prosecution wants second best. They want that record that they have of what the witness said outside of court. Can they bring it into evidence? We've seen some serious changes in the constitutional doctrine on this question over the last decade or so. The pivotal case these days is Crawford v. Washington. Crawford got rid of an older approach from Ohio versus Roberts, a 1980 case. There are some signs now that perhaps the law is drifting back in the direction of Ohio versus Roberts. The basic story in Crawford is this. Michael and Sylvia Crawford want some kind of satisfaction from Kenneth Lee, who attempted a rape on Sylvia, and so they go to Kenneth, and eventually Michael stabs Kenneth, kills him. Michael and Sylvia give their statements to the police. Michael claims self-defense. He says, I stabbed him, but I only did so because I thought that he was reaching for some weapon and I had to stab him before he could kill me. Her statement arguably undermines his claim because she says she saw Lee reach for something, maybe a weapon, but only after Michael attacked him. So her statement could really hurt his defense at trial. At trial, however, she's not available to take the stand because she invokes a spousal privilege and says, under the law of this state, I don't have to testify against my spouse. So the prosecution says, okay, second best, we want to bring in her statement to the police. And the question is, can you bring it in? Now, under Ohio versus Roberts, the older legal regime, the question was, are there adequate indicia of reliability for this statement? And if there are, then you can bring it in. In this case, the lower courts said, yeah, there's enough here because it was a statement against her penal interest. There's a traditional hearsay exception that would allow this in. But the Supreme Court here says, no, this statement can't come in. First of all, it was a testimonial statement, and that's a new term of art, testimonial. Once you have a testimonial statement, that statement can't come into evidence in trial unless, first of all, the witness is unavailable, and second, the prior statement was subject to cross-examination. Basically, these conditions are virtually never met. And this is an opinion by Justice Scalia. In fact, this whole Confrontation Clause project is one of the major priorities for Justice Scalia over the years. Justice Scalia identifies the core concerns of the Confrontation Clause as something other than reliability for the sake of reliability. He says, first of all, if you look at the text, it doesn't tell you much about the purpose. So if you look at history, what it gives us is negative examples. For one thing, it gives us the framers' concerns about the trial of Sir Walter Raleigh, pictured here. He was convicted based on a letter and some Privy Council testimony of his alleged co-conspirator in a treason matter. Basically, during the constitutional debate, the lack of protection for confrontation in these contexts was noted and condemned because it allowed the common law to be replaced with foreign civil law practices. So the main evil here was ex parte examinations as evidence. That is, somebody outside the courtroom and away from the classic adversarial process of testing evidence makes a statement, and now it's coming in without that testing. So the whole test here turns on this question of whether a statement made out of court is testimonial. This is a brand new doctrinal category. What we do know is that the court gives a few examples in Crawford and says that testimonial statements would cover prior trial testimony. If a witness had testified to something in another trial, then that would be testimonial. Or in a preliminary hearing, perhaps statements to police, particularly during custodial interrogation, that would count as a testimonial statement out of court, and therefore the preconditions listed in the Crawford holding would have to apply. The court also says that testimonial statements won't cover what the court calls an offhand overheard remark. It wouldn't cover business records or statements in furtherance of a conspiracy. Those are not the sort of thing where a witness is in effect practicing for court or making the sort of formal statement that might show up as evidence in later proceedings. The court also says that there's a special historical exception for dying declarations. Those are probably not barred as testimonial. So you get some clue about what counts as testimonial from these examples. Will this special set of constitutional limitations on the in-court use of these out-of-court statements serve ultimately the goal of accuracy? Justice Scalia says that's not the question I'm asking. I mean, it may result in that, but the framers, he said, weren't interested in case-by-case accuracy determinations. He says what they were interested in were systems. And so they're interested in the jury trial right as a system for appropriate fact-finding, and they're not asking whether a jury trial should be available for a given case depending on the strength of the evidence. It's just a categorical judgment. And similarly, he says here that we have to rely on cross-examination as an institution, whether or not we think it's going to add value in a particular case and lead to more accurate results in any given case. It's just available to a category of defendants. In this case, the category is those who are facing evidence from out-of-court testimonial statements. Now, where does this doctrine matter the most? It matters in two different settings. First of all, it matters in domestic violence settings. It's very often true that a complaining witness, typically the female, the wife, who originally files a complaint, tries to get help from the police, and then later on becomes unavailable because she's no longer very enthusiastic about testifying in the assault charges against her husband or significant other. And so once the witness is no longer available, can you bring in her statements to the police, the things that she said on the night of the event, rather than depend on her testimony in trial subject to cross-examination? So this is a very critical doctrine in the domestic violence setting, some other related violent crimes. And it's especially an important doctrine for the use of scientific evidence, because very often, say in drug cases, you have to have a lab technician say that white powder that you found on the person of the defendant is indeed cocaine or heroin or whatever it is. The same would be true for driving while under the influence. In that setting, some kind of scientific testing has to happen on the breathalyzer or the blood test that is the foundation of the evidence for the prosecution in many of these DWI cases. So first, let's take a look at the scientific evidence context. Melendez-Diaz versus Massachusetts is the first in this line of cases. Here you've got written statements called a certificate of analysis coming from the state crime lab, and these certificates say, here's the result of my testing, and here's the kind of instrumentation that I used. And the court says, no, you can't use that certificate of analysis, a written statement created out of court, to be valid evidence in court because it can't be tested by cross-examination. It's testimonial. Therefore, the Crawford rule applies, and the conditions can't be met here, so you can't use this certificate as evidence. Similar case, Bullcoming versus New Mexico from 2011. A crime lab report describes a blood alcohol analysis. Court says that report is testimonial again because it addressed the chain of custody of the blood that was analyzed. Even though the report was introduced into testimony at trial by a representative of the lab, it wasn't the analyst who had actually completed this particular report, and therefore there was some sheltering from the rigors of cross-examination. I want you to notice a pattern here. The government loses early, but they start to win later, and that happens also in this scientific evidence context. In Williams versus Illinois from 2012, we've got a bench trial for rape. Some evidence coming in from reports from a private lab that was working on DNA testing. And the court upholds the use of this evidence because it was created at a time when the defendant here, Williams, was not a suspect. So we're starting to get at least an initial exception to the rigors of Crawford in the scientific evidence context. I want you to think about the practical hurdles involved in getting this scientific evidence in front of a judge for a bench trial or a jury for a jury trial. Normally, you're not talking about a lab that is in town. You're talking about very often a state crime lab that's, say, in the state capital, or maybe some regional crime labs that are scattered through the state, but it's not like 3 blocks down from the courthouse for most prosecutors' offices. Therefore, you're talking about an analyst who has to drive into town. And if I've got a whole list of DWI cases or drug cases, and I need live testimony from the analyst, I've got to schedule all of my witnesses and everybody to be ready for trial on the days when the analyst can come to town. And typically the defense lawyer, of course, would know this and will raise a motion for continuance. And the normal tradition is, yeah, you grant the first, maybe the second continuance. And so the defense is able to say, the analyst is here today. I'd like a continuance. And so the analyst is going to have to drive from the state capitol several different times. Maybe they can't make it one time. That's the day the defendant looks around and says, not here today. Yes, we're ready for trial, Your Honor. The main evidence isn't available, barred by Crawford from out-of-court statement use. And therefore, case is inadequate. You don't have the proof of what that white powder was or what the blood alcohol analysis said. So it's a practical scheduling problem that is a powerful one, not a trivial question for large categories of cases, drug cases, DWI cases. Crawford has created a major logistical set of challenges for prosecutors here. Now let's take a look at the second major application context for Crawford claims, and that's emergency field statements. This is very often going on in domestic violence cases, but it could also involve other violent crimes. A string of cases here as well. Davis versus Washington from 2006. We've got a call coming in from a woman whose boyfriend is, as she put it, here jumping on me again and using his fists. And because it's happening right at the moment, the statements ultimately can come in. The court says this is non-testimonial. It's okay to use it because she's not really in the frame of mind of preparing a case with the prosecution for eventual trial. She's just trying to get immediate help. On the other hand, on the other end of this spectrum is Hammond versus Indiana, also from 2006, another domestic disturbance call. But this time, Amy Hammond is alone on the front porch when the police arrive. He's not, there using his fists immediately. Herschel Hammond, the alleged abuser, is inside, and so the police see some evidence of a fight inside from earlier in the evening. He gets angry when the police try to keep him separated from Amy, but she completes an affidavit. She's making statements to the officers. At that point, the court says it's less like an emergency sort of rescue mission, and it's more, this is part of the process of building a file for eventual criminal prosecution. And so the court says that's testimonial, and her statements to the police can't be used. She's going to have to come in and testify herself for this proof to make it into the case. An interesting turn of events in 2011 in Michigan versus Bryant. Here we're not talking about a domestic violence situation, but another violent crime, a murder investigation. And I won't walk through all the facts here because you'll be familiar with those from your reading. But I do want to flag a couple of things about the doctrine. The court's conclusion here again is that the prosecution can use the statements of Covington, who was the victim of the alleged crime, and it's another example of an ongoing emergency, therefore not testimonial, and therefore the Crawford limits don't apply, and you can use the out-of-court statement as evidence in the trial. Justice Sotomayor writes for the court here, and she describes the ongoing emergency exception a little bit differently than it has been in the past, perhaps a lot differently. So she says that now we're not so much asking is an emergency, but an emergency is one way of finding out about the primary purpose of the interrogation, of the conversation, from the point of view of the declarant, from the person speaking out of court. And you might get at that through the emergency nature of the situation, or you might get at that through the informality of the situation. You might get at that through the content of the questions and answers. But the basic point is you're trying to get at the purpose of the declarant. Was the declarant trying to start to build a criminal case to cooperate with the police and the prosecution in that venture? So you get a sense from this opinion that Justice Scalia's objective in Crawford to create a nice, clean, bright line rule is still out of reach. Certainly the court in Bryant was very interested in the specific circumstances. The court says we want to make an objective determination of the circumstances, and it's very fact-specific. So the court says that the circumstances of a domestic violence case call for a different analysis from the circumstances of other violent crimes, that the testimonial versus non-testimonial nature of a statement might change over time. As more time elapses, you're more likely to get into the world of testimonial statements. So this is certainly a very fact-specific inquiry. It's just that we're now using somewhat different terms. We're asking about the testimonial versus non-testimonial nature of statement rather than the Ohio versus Roberts test of indicia of reliability. But we will be working with these concepts, getting more familiar with how they play out in these high-volume settings when we next time get together. So see you then.